Thank you for joining us for our regional webinar on the impact of recent USCIS Policy Manual changes on immigrant survivors. My name is Kelly Byrne. I use she, her pronouns, and I am a staff attorney at ASISTA. A few housekeeping matters before we start. This webinar is being recorded, and the recording will be sent to all registrants in the days after the webinar. All of the materials were emailed to you before the webinar. If you don't have them, please check your spam folder. And if you don't see them there, please request them by emailing ASISTA's operations manager, Maria Lazzarino, and I'm putting her email in the chat box. We'll try our best to answer your questions today. We will have designated question and answer periods, and you're welcome to also pop your questions in the Q&A box throughout the webinar. If we do not get to your question, please review the slide that explains how to get in touch with ASISTA for technical case assistance. I'd like to thank TA to TA staff for moving the slides for us today, and to Maria Lazzarino for everything she does for ASISTA behind the scenes. Our work would not be possible without her. An evaluation will pop up at the end of the webinar. Please take a moment to fill it out. We do read all of your evaluations, and we use them to help us plan our future trainings. And now I'll turn it over to my co-presenters to introduce themselves.
Hi, all. I'm Christina Velez. I'm the Legal and Policy Director here at ASISTA, but I am very grateful for Kelly for leading the charge here. I'll be joining you in a few minutes.
And hi, everyone. My name is Carrie Tyrrell. I am a senior attorney with the American Bar Association's Commission on Domestic and Sexual Violence. And we're so grateful for ASISTA inviting us to be here today. You'll hear from me shortly as well.
Thank you both. And the OVW disclaimer, next slide, please. So here are our learning objectives. The hope is that by participating today, you'll be better able to describe policy manual changes regarding VAWA Self-Petitions and 1367, to determine how USCIS may adjudicate certain case types after implementation of these new changes, to adapt your practices to the new requirements, to identify the unique needs of LGBTQ+ survivors going through immigration processes, and to develop strategies to address the needs of LGBTQ survivors going through immigration processes. Next slide, please. So for our agenda, we'll discuss the VAWA and the 1367 policy manual changes. And within that discussion, there will be some guidance on how to enhance perception of survivors' credibility. Then we'll pause for Q&A, and then Carrie will talk to us about the impact of these changes on LGBTQ+ survivors. Then we'll have another Q&A period and takeaways. Next slide, please. So I'm going to start by talking about the VAWA Self-Petition Policy Manual changes. Just to note that these changes were effective on December 22nd of last year, and they apply to both pending petitions and petitions that will be filed in the future. Next slide, please. So evidentiary matters. In this guidance, USCIS has conceded that any credible evidence, or what I'll call the ACE standard, is statutory, but they have really honed in on their discretion. They've noted, a definition of credible evidence, which is that it's externally and internally consistent, that it's plausible, and that it is sufficiently detailed. We've been encouraging practitioners for a while now to submit detailed survivor affidavits, and it's going to be even more important now. In these changes, USCIS has said that affidavits should generally contain extensive detail about the person writing the affidavit, including their address and their place of birth. And they've stated that they will not give as much weight to affidavits that lack this information. They've also imposed new requirements on photographic evidence, although I will say even during the Biden administration, I saw a lot of USCIS notices that were contesting photographs. But anyway, I digress. So these requirements, they include to identify the person taking the photo, as well as the date and location of the photograph. Regarding psych evaluations, which I know a lot of folks include, USCIS is now saying that they want proof that the evaluator either treats the survivor or that they thoroughly and adequately evaluated them. So it's important that the evaluation is detailed and that the evaluator explains how their professional training and experience led them to make a particular diagnosis. And you also need to be including the evaluator's CV or their professional certifications. Regarding survivors who have submitted fraudulent documents in the past or knowingly made a false statement, that will undermine the credibility of all of the evidence in the self-petition. So if you're working with a survivor who has made a false statement in the past to USCIS, it's critical for them to obtain corroboration of the statements that they're making in the self-petition if that's possible. And if you can connect any past false statements to the abuse, that lets you argue that it's not a voluntary false statement. And if a false statement isn't voluntary, then it can't have an impact on the survivor's credibility. Next slide, please. So the prior language in the policy manual regarding qualifying relationships said that survivors should submit proof of termination of the abuser's prior marriages, so not their own, but the abuser's. Now it says must. Um, there are a lot of reasons why this is problematic, but if you can consider submitting alternative proof if the survivor doesn't actually have like the abuser's divorce certificate, along with a statement from the survivor about why they can't access that, and evidence in supporting an intended spouse argument as a backup. That is still available because it is statutory, so USCIS can't change that without Congress. And for intended spouse, you would need evidence of 4 elements. The first, that the survivor believed that they married the abuser. The second, that the survivor and the abuser had a marriage ceremony. Third, that the survivor believed that the abuser was free to marry. And 4, that the only reason that the marriage is invalid is because of the abuser's bigamy. So that's an alternative argument you can make if the survivor just can't get that proof of termination. Next slide. So battery or extreme cruelty, one of the big points here is that USCIS has said that the abuser must have been a U.S.C. or LPR at the time of the abuse. Their sole justification for this is matter of LLP, which held that the abuser in a VAWA cancellation case must have been a U.S.C. or LPR at the time of the abuse. USCIS didn't offer any reasoning for why they're using matter of LLP, which is significant because that decision's reasoning was based on a statute whose structure is very different than the VAWA self-petition statute. After we submitted these slides, for those of you with clients in New Jersey, the Third Circuit rejected matter of LLP in a precedential decision, Cardenas v. Attorney General, and I'm going to pop a link to that decision in the chat. Arguably, because USCIS's sole justification for this rule is matter of LLP, and the Third Circuit has rejected that, the rule arguably should not apply in the Third Circuit. Again, though, I want to caution that we don't know yet how USCIS would view that argument. The policy manual also appears to apply a stricter definition of battery or extreme cruelty. It references dictionary definitions of batter that mention repeated blows, and a definition of extreme that includes the language to the utmost possible degree. So you're seeing how they're trying to impose a stricter standard for this element. When they're defining extreme cruelty, USCIS has maintained a focus on whether the abuser is attempting to control the self-petitioner, so that is something that remains. But generally, they are moving away from survivor-centered adjudication practices. And this means that we can no longer assume that VAWA adjudicators will know about DV dynamics. So it's going to be really important to include materials about that in your filings. There's an organization called the Learning Community that I included a link to in your index of materials, and they have some good materials about dynamics that you can include. This is going to be especially important if there was no physical violence in the relationship. It's also helpful if you have them to include detailed letters of support from DV advocates, and you might also consider research articles or expert affidavits from DV advocates or others with expertise on what DV might look like in a particular community, like for example, the LGBTQ plus community. Keep in mind though that there was some negative BIA precedent recently that came out about experts, so just keep that in mind when you are submitting expert evidence. And I just put that decision in the chat. Next slide, please. So joint residence, the new interpretation is a complete 180 from the 2022 interpretation. This interpretation also was the interpretation before 2022, and when it was the old interpretation, there was some litigation against it. So that is just something to keep in mind. And that litigation was successful. It was a district court case. And the old is new again interpretation of joint residence is susceptible to arguments that it should not be applied retroactively because it is such a substantial change from the agency's prior interpretation. Unfortunately, retroactivity arguments are not going to win at the USCIS level because they've already decided that this can be retroactive. And the survivor will be NTA'd upon denial if they're not lawfully present. But VAWA cancellation might be an option in these cases if joint residence was the only reason for denial, because joint residence isn't a requirement for VAWA cancellation. Next slide. It's a good moral character, because they're saying that failure to disclose criminal history, even if it's not actually material to eligibility, will be considered a negative factor. So the advice there is that survivors should disclose their entire criminal history to the extent permitted by law, even though the Form 360 doesn't ask about it currently. Regarding mandatory detention, the policy manual doesn't contain any difference between criminal and non-criminal basis of mandatory detention. So if someone entered without inspection and that actually resulted in mandatory detention, USCIS could consider that to be a negative factor in the good moral character analysis. USCIS has also emphasized that the passage of time alone, since a prior bad act, so to speak, might not be enough to demonstrate good moral character. They've said factors that you would want to consider in these cases are rehabilitation and severity, but they removed some favorable language that had previously required adjudicators to consider the totality of the evidence, including both positive and negative factors, when looking at acts outside of the 3-year period. All that said, if the past acts were related to abuse or trauma, or if the survivor has been rehabilitated, you can argue that those acts are not relevant to the survivor's present good moral character and that they should not be considered. Next slide. Another big change is USCIS has said that they can deny without first issuing an RFE or NOID. So because of that, it's really important to ideally include multiple pieces of credible evidence for each VAWA element at the time that you file, rather than relying on skeletal petitions. Obviously, sometimes you have to file a skeletal petition, like if you're on a deadline, but if all possible, please try not to do that. especially given the NTA policy. And if you have any pending petitions that are skeletal, I would recommend supplementing those now without waiting for an RFE. It also appears from these updates that USCIS field office employees who are conducting I-485 interviews, not just the VAWA unit staff, but these folks at the field office, can revoke approved self-petitions. And there is also no longer a policy that forbids these folks from asking about the abuse in 485 interviews. And in fact, just today, we heard a report of an inquiry into the underlying approved VAWA self-petition in an adjustment application that said we don't know yet whether that was a one-off or this is a new trend, but this is something that we are keeping an eye on. A couple things on this. Number one, there is a regulation that requires USCIS to give notice and an opportunity to respond before revoking a VAWA self-petition. I'm going to put that regulation in the chat. I would bring that cite with you to every interview. And if an officer tries to, revoke on the spot, I would argue that that's not permitted. And if they keep insisting, I would ask to speak to a supervisor. And on the issue of re-adjudicating the self-petition, even though now there is no longer like a policy that you can point to, you could argue that specific facts of the abuse are irrelevant to the I-485, and that USCIS has already had a chance to fully assess the evidence of abuse that the survivor submitted. And then also if the survivor has a therapist who's willing to attest to trauma that they would suffer from having to recount and relive the abuse, you could bring a copy of that to the interview. And then also, if they still insist on re-adjudicating 360 and perhaps revoking it, there are also administrative law principles about certain practices that agencies have to follow if they're going to change their position based on the same record. Next slide, please. So now we have a hypo. We have Devika. She entered the United States without inspection, and she is married to Paul, an abusive U.S. citizen. And they share a 4-month-old child, Tyler. Paul had told Devika that real mothers nurse and don't work, and that he would have her deported if she tried to get a job. She has issues with her milk supply, but Paul has also refused to buy formula for their child or to give Devika money to buy the formula herself. Desperate to feed their child, Devika shoplifted formula while Paul was at work. And she was arrested for this, but the case was recently dismissed on speedy trial grounds. So the questions are, how might this arrest impact good moral character? And how would you discuss this with Devika? So if you have any thoughts about that, please feel free to put them in the chat box. I see have someone saying explain coercive control. Yes, definitely. Anybody else? A letter from the physician regarding milk supply. That's a good idea. Because that can help corroborate what Devika is saying, which helps make her seem more credible. Financial abuse, yeah, exactly. So there's a couple things going on here. One thing that USCIS might bring up is that theft. Devika has entered without inspection in the Lake and Riley Act, which applies to folks who entered without inspection. Does have theft as one of the offenses included there. So USCIS might be like, theft, Lake and Riley Act, mandatory detention, negative factor. But one way that you could respond to that is that the policy manual uses the term resulting in mandatory detention. I'm not, just eligible for. And Devika hasn't actually been detained as far as we know. So if USCIS tried to use the Lake and Riley Act against her, that's an argument you could make. But I think the more important argument is like what folks have been alluding to in the chat is trying to connect this to the abuse. Again, like the fact that Paul had controlled her by, forbidding her to work, forbidding her to feed her child in any way besides nursing. And the argument is that she would not have shoplifted if not for this extreme cruelty. So you'd want to show with evidence how the threat of deportation affected Devika and how this insistence on, both nursing coupled with this refusal to give her resources to feed the child any other way amounted to coercive control and an attempt to isolate her. And then you can point to the fact that there is a statutory waiver for conditional bars to good moral character that are connected to the abuse. And you can point to the fact that that waiver exists as evidence that Congress's intent is that acts that are connected to the abuse should be treated differently and more leniently in the good moral character analysis. All that said, GMC is a discretionary determination, and discretion is tightening. So unfortunately, I don't think it's going to be enough to just show the connection to the abuse. I think it's also going to be important to show evidence of positive equities. Next slide, please. So retroactivity, again, at the agency level, USCIS has already decided that these changes can be retroactive. But for folks who want to try to obtain a different result in federal court, it's important to have retroactivity arguments in the record. So here on your slide is a test from the BIA on retroactivity. And you'll see that the test applies to agency rules and that this is, a policy, so it's slightly different. But I'd argue that retroactivity, it's ultimately a question of fairness, and the same amount of unfairness results from retroactive application of an outcome determinative agency policy as it does to retroactive application of an agency rule. And I think the arguments against retroactivity are the strongest for the joint residence change and the change regarding step-parent relationships, where USCIS has said that the relationship has to continue after filing. Both of those are the complete opposite of the 2022 policies, and clearly folks who filed after February 2022 would have relied to their detriment on those old interpretations. And for a favorable, so an example of the BIA finding favorably on retroactivity, the recent decision on 237A1H waivers, matter of 4Jo, which is in your materials. You can take a look at that to see the type of analysis that you can make regarding retroactivity. Next slide, please. So practice tips, again, emphasizing that corroboration is going to be important because it helps with credibility. And corroborating even things that might seem small can be very helpful. Of course, you're not always going to have corroborating evidence. And I'm just going to be honest with these changes. Those cases are going to be uphill battles. They're not going to be easy to be approved. But if the survivor wants to move forward despite the risks, they should explain in, their affidavit why there isn't corroborating evidence. And then you can argue that corroboration is ultra vires and it's contrary to the congressional intent, which is allowing DV survivors who may lack documentation to be able to pursue relief independently of their abuser. And then you can also argue why the survivor is credible, even though there is no corroboration, pointing to some of the other reasons that USCIS has said evidence is credible. So, for example, that it's externally and internally consistent and that it's detailed. If the survivor's statement meets those requirements, you can argue that they're still credible despite the lack of corroboration. Briefing the reasons behind the any credible evidence standard is going to be very important because USCIS removed policy manual language that explained why that standard was created. And there is some legislative history on NUAP's website that might be helpful. So I'm going to put that in the chat. And that since you have to show that joint residence is during the qualifying relationship, and in most circuits that the abuse occurred when the abuser was a USC or LPR, make sure your pending cases have enough evidence of those two things. And if they don't, supplement them now and don't wait for an RFE. And I will now turn it over to Christina.
Thank you, Kelly. There's some intermittent noise coming from behind me because of some construction in my building, so I apologize for that. Yes, we will now turn to 1367 Policy Manual updates. These were also made effective as of the day of their release on December 22nd to all pending and newly filed applications. Let's go to the next slide. Right. So before we dig into the policy manual changes to 8 U.S.C. 1367, I wanted to give a little background. The 1367 protections were enacted in 2006, and this slide shows what the statute actually says. 1367 encompasses two provisions that apply to all protected persons, meaning those who have filed UT or VAWA related applications. That includes VAWA cancellation, VAWA self-petitions, and I-765V applications for work permits for abused spouses of non-immigrant visa holders. First is the prohibition against the use of information furnished by an abuser or perpetrator to make an adverse determination of the non-citizen's inadmissibility or deportability, subject to an exception where the protected non-citizen has been convicted of certain crimes, which we'll talk about soon. The second is the prohibition against disclosure of information referring to the protected person to anyone outside of DHS, DOJ, or the Department of State, except in some limited circumstances. So most of us have known 1367 protections to be applied much more broadly to essentially protect access to information about the survivor's applications and also protect against the abuser's efforts to manipulate the immigration process against the survivor applicant more generally, such that any information provided by an abuser or perpetrator is viewed as inherently suspect by the decision maker for all purposes, and that USCIS will, quote unquote, obtain independent corroborative information from an unrelated and not prohibited source before making an adverse determination. The policy manual changes that are most significant apply to this first provision, the so-called prohibited source provision. In the policy manual updates, USCIS announced its intention to apply the provision as written, which is far more narrowly than it had been previously. So I suspect that I suspect that this was not done previously because I think it's going to be incredibly difficult to implement in that way. And we'll discuss that. We're not going to talk a lot about the non-disclosure provision, so I wanted to note up front that DHS has always interpreted the non-disclosure provision to allow the different subcomponents of the agency, that is ICE and USCIS, for example, to share information about 1367 covered applications or people. The non-disclosure provision contains an exception for legitimate law enforcement activity, but again, even then, they are required to maintain the confidentiality of the information to the extent possible. This is, you know, previously we did not see DHS initiate removal proceedings using information obtained from protected applications, and we're starting to see that now, or we're seeing reports of that now anyway. But that what previously did not happen. But that was not because of anything in the statute. All right, let's go to the next slide. So what is significant about this new 1367 guidance is that it does not anymore require USCIS adjudicators to view as inherently suspect information that is provided solely by abusers. And for the rest of my portion, I'm going to say abuser, but I also mean perpetrator or trafficker. So it does not require USCIS to view that information as inherently suspect for all purposes, except it does when determining inadmissibility and deportability, because that is what the statute says. What this means is that when it comes to the elements of relief that don't have to do with inadmissibility, the abuser provided information can come in, and the policy manual says that adjudicators can consider that information without requiring or seeking independent corroborating evidence. So the updated policy manual says that that information should be evaluated using accepted practices for determining the information's credibility. And that includes considering the apparent motivation of the source, the reliability and credibility of the statement in the context of other evidence in the record. The policy manual update also states that officers do retain the discretion to corroborate third-party statements or abuser statements by third-party sources on a case-by-case basis. So folks who are receiving RFEs or NOIs or decisions that rely on prohibited source information, abuser-provided information, should cite to this policy manual language and argue why it should be erroneous for USCIS to rely on that information in that particular case. In terms of VAWA, this is especially concerning because abusers can allege a lack of good faith marriage. And this is one of the examples provided in the update itself, which suggests that they anticipate that this will happen. As many of you know, this is one of the easiest ways for abusers to try and undermine a survivor's claim for relief. For U's and T petitioners, information like that could come into a discretion, as far as discretion or a determination of culpability for the qualifying crime or trafficking, depending on what kind of information is being provided by someone who's trying to undermine their eligibility for relief. The provision textually as written also includes this weird exception that allows DHS to consider abuser-provided information for admissibility purposes if the beneficiary, even for admissibility purposes, even if the beneficiary has been convicted of an offense under INA 237A2. Even if that offense has nothing whatsoever to do with the information being provided by the abuser or with the application being filed at all, or even if the doesn't even impact necessarily the beneficiary's propensity for truthfulness. It's just weird because 237A2 relates to deportability, not inadmissibility. And survivors applying for VAWA, U, or T relief are usually affirmatively seeking immigration status, not defending against charges of deportability, except in this, the VAWA cancellation context. let's go to the next slide. Talk a little bit more about that. So let's look at what offenses are included in 237A2. So if you look at the actual statute again, 237A2 covers much more than criminal convictions. It includes non-criminal grounds and admissions as well. But for the purposes of this exception to the prohibited source provision, we are looking only at grounds that require convictions because that's what the 1367 text says. So these grounds include CIMTs, aggravated felonies, controlled substance offenses, except for that single offense of simple possession of marijuana, firearm offenses, and crimes of DV. Although I will note also that 237A7 of the same statute allows a waiver of DV related deportability where the survivor was not the primary perpetrator of the DV and meets the other criteria there. So I would argue for this waiver to also be applied wherever it can be if DHS cites to the exception that allows them to consider abuser provided information when determining admissibility and deportability. So another thing that we have noted is that several of the 237A2 offenses shown on the slide, because they relate to deportability, include after admission language. So, for example, one CIMT within 5 years of admission, two CIMTs anytime after admission. So where there's after admission, that is italicized on the slide. So that we don't yet know how courts will apply this exception or the language of 237A2. But we urge folks to cite to this text and argue that if their client has not yet been admitted, the subsection relating to offenses committed after admission should not apply to them. And for those who were admitted on valid visas and overstayed, I might also cite the within 5 years limitation for CIMTs where that's applicable. If they're going to adopt a purely textual interpretation of 1367, then we can focus on the text as well. Unfortunately, there is some precedent for applying these deportability provisions to limitations of eligibility for cancellation of removal in that context for folks who are not yet admitted. And that has happened in a Supreme Court decision in 2020 in a case called Barton v. Barr. But we don't know if that's going to be the interpretation that courts adopt for this. So again, it's not entirely clear to me how this new policy manual interpretation of 1367 will come up in litigation, possibly through VAWA cancellation cases and raised up through BIA appeals to the circuit, or possibly in APA litigation. I'm also not sure how clearly USCIS will explain its decision-making process around applying this prohibition and the exception. It's going to be very important for folks to FOIA and request derogatory information relied upon by USCIS. There is a separate section of the policy manual that applies to that, and I'm going to put that site in the chat. Let's see. There is that. And then there is also a regulation at 8 CFR 103.2, and I will put that in the chat as well, along with what it says. It's a footnote from our practice advisory. So that says that if a decision will be adverse to the applicant and it's based on derogatory information, of which the applicant is unaware, they can be advised of this. They should be advised of this fact and offered an opportunity to rebut the information and present the contrary information before the decision is rendered. And then there's some exceptions there. So I would take a close look at the policy manual section around derogatory information and this regulation, and make use of it where you are aware through the use of RFEs or NOIDs or written decision that USCIS considered adverse information provided by a prohibited source or an abuser, rather, perpetrator or trafficker against your client. So I know it's a little tricky, so we're going to take a poll and see how well I explained this. Let's go to the next slide. So, Sandra was admitted to the U.S. with a student visa and was later convicted of cocaine possession. She's married to an abusive U.S. citizen and wants to file a VAWA self-petition. Can USCIS determine that Sandra is deportable based solely on information furnished by her abusive spouse? Yes or no? I'll give everyone a chance to respond. I can't see the amount of responses. Oh, great. Thank you. Okay, so looks like 56% of you said no and 44% of you said yes. What's the answer? The answer is yes, they can. So, but because of all the double negatives, yes, USCIS can determine that Sandra is deportable based solely on information provided by her abusive spouse. This is because as we discussed, the prohibited source provision prevents USCIS from considering abuser-provided info for admissibility and deportability unless the beneficiary has a conviction covered by 237A2. Here, Sandra has a conviction covered by 237A2, and so that prohibited source prohibition provision doesn't apply in her case. Doesn't apply. So they can decide that she's inadmissible or deportable based on something her abusive spouse said. Okay. And then it's up to us to continue to argue that it's not credible using even accepted methods of determining credibility, right? Let's go to the next slide. We have another poll. Okay. Ali is married to Soraya, an abusive LPR. He does not have any convictions. Soraya has frequently threatened to call ICE on Ali. Ali filed a VAWA self-petition and is worried that USCIS might find that his marriage to Soraya is not in good faith if she calls ICE and says that he only married her for a green card. Are Ali's fears well-founded, yes or no? Okay, let's see. 58% said yes, 42% said no. Unfortunately, Ollie's fears are well-founded. The answer is yes. As we said before, the narrowed interpretation of 1367 now allows DHS to consider derogatory abuser-provided information to determine eligibility for relief. Ali should not be, however, I think Ali should be provided an opportunity to contest Soraya's accusations, assuming they are unaware of Soraya's accusations, or even if they aren't still derogatory information, that they should have the opportunity to contest. There may also be some contextual information that might be helpful in the learning community material that Kelly spoke about earlier, about how abusers are commonly known to manipulate legal systems against the people they are seeking power and control over. So that is something else that could come into play when you contest the credibility of the information that's provided by the abuser. Let's go to the next slide. Now, there are additional things included in the 1367 Policy Manual updates that I know are super important to practitioners, just on a practical level. So I'm going to review those, and then some practice tips, and then I'm happy to turn it over to Carrie. So the miscellaneous items that are included in the 1367 Policy Manual updates. A lot of chatter has been about this address language. So in these policy manual updates, USCIS has stated that the registration and change of address requirements apply to protected persons, and that protected persons are not excused from providing a physical address when required by a form. As we speculated, when the registration IFR came out, I guess, well, I don't even know when it was. It was some time ago, and everyone was talking about do my UNT petitioner clients need to complete the registration requirement? Here in the policy manual update, USDHS has confirmed that yes, they do. They did not speak to the question of whether a UNT petitioner who has already completed biometrics is considered already registered or not. They did not answer that question. That's still kind of an open question. But it has been coming up a lot on our listserv and everywhere else that the physical address requirement has been difficult for practitioners to deal with, especially where their clients maybe are not confident that USCIS will use a safe address instead of their physical address to send important mail, where they are also not confident that this information will be used for purposes of enforcement. So this has been very difficult for practitioners to work around. There have been a lot of questions about it and rejections, but also receipts of applications using confidential addresses or addresses of the attorney. So it's still a little bit, I would say, inconsistent. But this is what the policy manual says. So we should all know that. USCIS also in the policy manual update said that the 1367 protections end when the person naturalizes. Before it said that when it comes to denaturalization, which we're also kind of hearing some chatter about, although we haven't really seen a lot of survivor cases involving denaturalization efforts. But it said that when it comes to denaturalization, they can the protections will reattach upon initiation of denaturalization proceedings. So previously it had said, instead of initiation, it had said consideration of denaturalization proceedings. So it's a minor change, but it could have some impact. We'll see. Finally, USCIS implied that attorneys or accredited representatives can call the contact center without the non-citizen. They did more than imply. They said they could. So we're hoping we have received reports that has uh, has been happening. People have been able to use the contact center without their client sitting next to them or on the line, and that is the one bright spot in all of this. So I'm happy to bring that news to anyone who was unaware. Let's go to the next slide. All right. So here we have some practice tips to close out this section. We advise folks to recognize that USCIS and DHS, I think, uh, will apply the prohibited source provision very narrowly according to the text of the provision, which we know doesn't really make a lot of sense, but that's what they will do. We recognize that this will be difficult for some criminalized survivors who may find themselves falling into this exception to the prohibition on prohibited source information consideration. But it's very, like I said, like we said, that we still have some questions about what's the proper way to apply that. And I really encourage people who have clients in this situation to keep in touch with us and let us know what kind of what kind of notices there and requests they're receiving from USCIS that seem to indicate that this is happening, that this exception is being applied against their client. We would also encourage folks to argue that regardless of the prohibited source provision, regardless of whether DHS is supposed to consider abuser provided information as inherently suspect, that information is not credible, right? And you have probably a lot of reasons why they should consider abusers provided information not to be credible. And it's definitely, we urge you to make those arguments. And as I said earlier, there's some potentially helpful language in the policy manual updates. I would check that out, related to credibility, how to determine whether information is credible, and the like. Um, Brief arguments against retroactivity, again, I guess, for cases that were pending on December 22nd, that are impacted negatively by these updates. Prepare arguments on why certain criminalized survivors should still be protected by the prohibited source provision, maybe because they were not admitted at the time of their conviction or some other textual argument. Feel free to follow up with us to develop those arguments. And be prepared to cite these derogatory information provisions and file FOIAs and litigate those FOIAs if needed. Definitely get to the bottom of what's going on in your client's case if you suspect that it involves some of this kind of information. And with that, I will turn it over to Carrie. Thanks so much.
I think if we move to the next slide, there's a section for questions.
Oh, right.
As we move forward, we're going to apply this all to members of the LGBTQ community and look at specific issues you may encounter and to the extent possible ways to combat that. So before we do that, if anybody has any questions on these specific provisions or anything that Christina or Kelly has said, if you want to pop them in the chat, I'll give it a second. As we're doing that, actually, maybe we can move to the next slide because the next slide is a poll. And that poll is, have you ever worked with an LGBTQ plus survivor of domestic or sexual violence? I'm seeing some yeses roll in, lots of yeses, one no. Gonna give it a second or two. Lots of yeses. All right. So we see mostly yeses and one no. I would suggest that there's also a possibility that you may not know. First of all, some people may not feel comfortable reporting what their membership is in the LGBTQ community to your office whatsoever, and especially in intimate partner relationships that may involve different genders, someone may not report bisexuality. Bi erasure can appear in seeking legal services as well. If we move to the next slide, the next poll question is, how common is domestic violence, dating violence, sexual assault, and stalking in LGBTQ plus communities compared to the general population? All right, I'm seeing some answers. Give it a go. All right. Lots of different answers coming in there. Okay. I love that some people admitted that they don't know. I think that's great. I'm going to let you all know this is a tiny bit of a trick question. So the answer is a little bit that it depends on the breakdown. In general, overall, though, it's just as common or more common. If you move to the next slide, you can see that amongst transgender people, the rates of domestic and sexual violence are very high. 54% of transgender people report experiencing intimate partner violence sometime during their lifespan. 47% report experiencing sexual assault, and 68% of undocumented transgender people report experiencing IPV or intimate partner violence. That's an extremely high rate. If we turn to the next slide. Can we get the next slide? And then if we look by sexual orientation, so obviously gender identity and sexual orientation are two totally separate questions. You could have someone who has a different gender identity than sexual orientation, but if you look at this, obviously the rates for bisexual women are extremely high. You can see that actually the rates are very high as well for lesbian women, and then heterosexual women have slightly lower rates. Heterosexual men have slightly lower rates as well. So some of these differ a little bit depending on what surveys you're looking at, but in general, across the LGBTQ community, the rates are about the same as or a bit higher than they are for heterosexual members, heterosexual cisgender members of the community. Not only do we see higher numbers, if we move to the next slide, we can also see how abuse can show up differently within the LGBTQ community. And so when you're talking about proving extreme cruelty within the LGBTQ community, you want to be looking at these additional forms of abuse. Some of you may have seen various power and control wheels focusing on this. Given the size of the slides, I wasn't sure that would be the most useful prop here. But one thing to really look at, especially when you're dealing with immigrant survivors who are members of the LGBTQ plus community, is threats of outing as a form of control. Those threats may be even more frightening to an LGBTQ plus survivor in combination with threats to have them deported to a country that is hostile to the LGBTQ plus community. So if someone is saying, you know, if you do this or you don't do that, I'm going to tell your family and I'm going to send you back, that could be a really serious safety concern for that survivor. And that is something that you want to make sure you understand and that you're including in these applications. Additionally, another thing that we see in the LGBTQ plus community in terms of trying to prove extreme cruelty is very problematic conceptions of violence as mutual or even consensual, especially when gender is perceived as being the same between the members of the couple. We've heard some very problematic reports of law enforcement occasionally saying things like, oh, it's just a fight between men, or likening it to some kind of bar fight rather than recognizing these patterns of abuse and recognizing how they show up in an intimate partner situation. Additionally, if we move to the next slide, it can be even worse in that it can lead to an incorrect primary aggressor determinations. So some of you may have seen this already in some of your cases, where a more stereotypically masculine partner may automatically be perceived to be the abuser. And this can become an even bigger concern now, given what we just talked about the prohibited source. Since USCIS may now consider the abuse of partners allegations, but the survivor is the primary aggressor. If USCIS is engaging in any of these stereotypical views, that could be very difficult to overcome. One of the things you're really going to want to do, in addition to all of the FOIAing you're doing on a federal level, is you're going to want to know if there are any negative reports from state or local law enforcement. And if there is, you may want to consider ways to address those. And I've had to do this in various circumstances for some clients in the past. So there may be a process to amend or supplement. You may be able to go back to law enforcement and do another round of interviews, get that added to the police report if you're including that in your application. Another thing that I have done once is got a letter from in my jurisdiction, it was a state's attorney's office. It might be a district attorney's office, but saying essentially why they didn't charge, why they didn't move forward on the charges. You might also consider doing that for why charges were dismissed. That, yes, okay, an arrest was made, but upon additional investigation, further interviews, whatever it may have been, they reached the conclusion that this was not something that they wanted to pursue. This may be difficult to get, of course. I'm not trying to imply that this is an easy thing to do. It may also, you may encounter other challenges too of things being sealed in certain ways. You may be able to get a more general letter too of, reasons why cases would be dismissed. You can kind of try to see what type of relationship you can build with your local prosecutor's office and with your local law enforcement to see what options you may have there. But especially in light of the good moral character issues, anything that you can do to reduce the likelihood that that's going to be used against your client is really important. And again, you can see how this really builds on for members of the LGBTQ community, where one negative police report, assumptions being made by USCIS, and all of this can compile together to make some really big concerns. If we move to the next slide, there could also be marriage fraud determination concerns. This may seem obvious to many of us on this webinar today, but if the LGBTQ plus survivor is from a community that may not be supportive of members of the LGBTQ community, or somewhere where LGBTQ plus identities can be a source of internal or external shame or even safety concerns, they may have hidden their relationship. In fact, they may have actively denied their relationship, told somebody that they're roommates or things of that sort. And that means fewer people who can attest to that relationship. Or if there's an investigation done, perhaps even more people who are going to say, no, this wasn't a romantic relationship. This wasn't a romantic partnership. They also may have less documentary evidence of their relationship. So one way to look at it is if having couple pictures around could have devastating social or even safety consequences, there's a huge incentive not to take those. So they may never have existed. So all of these things that some of us may take for granted that we have with our partners, there may be serious reasons within certain LGBTQ immigrant communities not to have done those things. So what do you do if you're encountering this? And draft an explanation as to what's available and why not. And I know that Christina and Kelly both touched on this, but be as detailed as possible. Maybe try to get some of those supporting condition type reports. And in some ways, it may start to look a little bit like an asylum petition of, hey, we know that this particular area may not respond well to this. If you're working with somebody from a specific DV or SA agency as well, and they're writing some kind of letter in support, can they throw something, if it's a culturally specific service provider, in there about their understanding of the community and why this would not be a safe or acceptable thing to have done. You also may want to consider if are a few members of the community that they were out to. Let's say there's an even smaller niche subsection of that community. Could those people include in their letters as well reasons why they're not out to the wider community? Next slide, please. Another big concern for members of LGBTQ immigrant community is maybe the affidavit requirements. As we highlighted earlier, previous language was any other credible evidence that demonstrates the self-petitioner's intentions for entering into the marriage. And now it's detailed, specific, and reliable statements or affidavits of persons with personal knowledge of the relationship. Next slide. So in addition to all the reasons that survivors may not be out to everyone within their communities, there's a risk that the content of the affidavit could out that affiant. And that affiant may not be comfortable submitting something that lists their address, that lists all this information about them, and lists how they know that this person was in that kind of relationship or where they were perhaps when a picture was being taken. Hey, I was at this gay club with my friends on this date, is risking outing them as well. And there can be potential consequences to even being seen as an ally, even if that person maybe doesn't self-identify, that affiant doesn't self-identify as LGBTQ, it may still not even be comfortable for them to be seen as an ally. As we mentioned before, the survivor and the abuser may not have been out to many other people and may have even told others that the relationship was non-romantic. Next slide, please. Just like I was suggesting, this goes to photos as well. And this could go to photographs of injuries as well. USCIS is now requesting photographs of injuries when the self-petitioner clearly identifies who took the photographs, as well as when and where they were taken. and when the photographs are fair and accurate representations of what they claim to depict. As I mentioned before, the identity of the photographer may risk outing the photographer. The survivor may have intentionally avoided taking those photos or having others take photos to avoid outing. So what do we do about all of this in total now that we're looking at all of these concerns? If we move to the next slide. Trauma-informed lawyering 101. The first thing we've got to do is we've got to discuss these issues directly with the client. Client-centered lawyering. They need to understand why this is going to be a problem and help identify prior and ongoing safety concerns. What kind of safety planning can you do around this? Is there a way to make this in some way safer for that particular survivor? And those safety issues may not just be for the survivor. You do want to let them know what would be asked of anybody that they're asking to submit a letter from and talking about ways to address that and whether that's something that they're comfortable asking that person for. And as we say in every one of our other trainings, this is the survivor's choice, ultimately, at the end of the day. We can advise them about the likelihood of success on one path or another, but they need to understand what risks they are taking. They should also be safety planning to the extent possible about outing concerns. If this does not go well and somebody does become aware of this in their community, how are they going to address that? Obviously, as well, draft the explanation as to what's available and why not. And if possible, link the lack of evidence to abuse. If the reason they weren't taking couple pictures is because they were scared that the perpetrator was going to send those out to everyone that they knew, to their family back home, include that. Highlight that. Say, I was unable to include any photos because my partner threatened to use them. The abuser threatened to use them to out me to my religious community, my cultural community, whatever that may be, my employer. And you can still use any credible evidence. That is still the standard. I know that Christina and Kelly both highlighted that, but continue providing all of the evidence that you normally would. We're going to move now into a hypothetical. If we go to the next slide, this is about Elena. I'm going to read it out loud. You can read it yourself as well. Elena met Nadia when Elena was visiting the United States from Russia. Elena and Nadia got married at a courthouse. After their marriage, Nadia became physically abusive towards Elena. Nadia repeatedly told Elena that no one would believe her and that she'd have her deported if she told anyone about the abuse. Neither Elena nor Nadia are publicly out to their families or the Russian expat community. Elena and Nadia referred to each other as roommates in public. All right, so if you can pop into the chat some questions you might ask Elena about types of evidence she might have that could demonstrate the sincerity of her marriage. What might you want to just ask about? And I know you all do this all the time, so I'm curious to see some of these things. Anybody got any thoughts about what you might want to ask about in terms of evidence? Who was with them at the courthouse? Perfect. There we go. Text messages. Yes, excellent. Gifts, proof of trips together, such as hotel and transportation receipts. I love that. Those are great suggestions. That's a way to think out of the box. Photographs. Yep. Did they take any? Just because I said there might be reasons that they didn't doesn't necessarily mean that they didn't. Anybody else got any other suggestions? Are they out to anyone outside of the expat community? Any affidavits? Yep. That was something that I was intentionally leaving there. How did you meet? If on a private social platform, provide proof of the initial chat. These are great ideas. One of the first things that come to my mind is they had to have some kind of witness at that courthouse. Who was there with them? Who was their courthouse witness? Lease agreement, same address on driver's license. Yep. Now, of course, the risk is that obviously Elena and Nadia have been out as roommates. So even if we can show that they live at the same address, that might not combat that. But that is still something that you do have to prove. So definitely want to have proof of that. I think another question that you might ask would be about, as someone said, whether they're out to anyone outside of the expat community. places they've gone together, things they've done together. I think you covered a lot of these different things to think about. You might also want to consider whether Elena talked to anybody else about the relationship. I mean, even if she was talking about this as if it were with someone else, maybe if you could corroborate the time frames, things of that sort. So moving on to how might you provide an explanation for evidence that Elena doesn't have? Anybody got any thoughts? Let's say she doesn't have those photos, or let's say, God forbid, Nadia is saying that this was a fraud. Well, what are we doing here? I know somebody earlier said, what are we going to do about this? Now it's my chance to ask you all, what are we going to do about this? While we think about this, I might say this is another great place where if you did find anybody within the community that they were out to, having somebody write a letter about why it isn't something that someone would feel safe doing. If there are culturally specific service providers there, having them potentially write a letter. Yes, homophobia in Russia is incredibly high. I lived over in Russia for a little while, and as somebody who identifies as a member of the community, that would be something that I would definitely want to be providing information and evidence about. Who do you know there that might be able to say that homophobia is very, very high there? If you have any of those text messages you were talking about earlier that threaten Elena with deportation or threaten her with outing, that could be really helpful to highlight as well. Does anybody have any other thoughts about other ways we might provide explanations for evidence that Elena doesn't have? Yeah, it really depends on the circumstances because some of it's what is missing. If you don't have lease agreements, then maybe why she wasn't officially listed on the lease here. That's probably not going to happen if they're referring to each other as roommates, but there are all sorts of different circumstances that might lead to different ways that we think creatively about this. And this is stuff that we've done all along. It's not brand new, but it's just going to be even more important that we highlight it now. So if we move on to the next slide. Sadly, the next two slides, I don't have any great solutions for us to brainstorm other than to just highlight their disparate impacts on the LGBTQ community. So the joint residence requirement changes, they are likelier to have a disparate impact. And USCIS, as they highlighted, is now requiring that the parties have jointly resided together after the marriage occurred. Obviously, check your previously filed cases to determine whether this evidence was included and to assess potential supplementation. But why am I bringing it up to highlight this here? Members of the LGBTQ plus community are statistically likely to have a first marriage at a significantly older age than heterosexual couples. It's hard to find a very recent survey, but as of 2023, there was a survey that showed that women in same-sexual couples were on average 33 at the time of their first marriage, compared to women in heterosexual couples who were on average 29. And then men, it's an even stronger difference. Men in sex couples were 38 at the age of first marriage as compared to 30 in heterosexual couples. So there may have been a long period of time where they were living together before they got married. Definitely check. Make sure that you've put in evidence if you have it. And this change in interpretation will likely be litigated at some point in time. So it's important to stay apprised. The other last thing to highlight is that the new policy does still permit even very short periods of joint residency to suffice. And they literally say the self-petitioner is not required to have resided with the abuser for any specific length of time. So even if you can prove that there was one day after they were married that they were residing together, put in that proof. Get that photo of the celebration at their joint residence into evidence. And if we move to the final slide we have on the LGBTQ specific topic, good moral character concerns. It's important to acknowledge that according to a very recent ACLU study, almost 20% or ACLU report rather, almost 20% of LGBTQ plus people have been arrested by the police, compared with 13.6% of non-LGBTQ plus people. And nearly 1/3 of transgender people have been arrested. We're looking at how the new good moral character interpretation is going to be applied, it's going to have a disparate impact. You may need to be more prepared to come up with those positive equities, to tie it back to the abuse, and to do everything you can to try to mitigate that for the LGBTQ community and survivors that you're serving. If we move on, I think that the next slide may have a moment for questions. Does anybody have any questions about how these changes in specific um, may impact the LGBTQ plus community? If not, then Kelly, I think I turn it back on over to you for the next slide.
Yeah, thank you. Next slide, please. So for our takeaways, the first is that USCIS guidance on the any credible evidence standard makes it critical to include arguments and evidence on domestic violence dynamics, especially for the LGBTQ plus community, and to review your filings for credibility and consistency. Be prepared to explain why certain types of evidence might not be available for LGBTQ plus survivors. Recognize that fewer immigrant survivors will be protected by the prohibited source provision. Prepare credibility arguments and prepare to address any improper primary aggressor determinations, and include copious evidence of positive equities when there is a chance of a good moral character problem. And then with the takeaway about credibility arguments, someone had asked a question like, how do we make these? I think Christina answered that a little bit. Um, but I would just add to it, consider how, you know, real courts consider credibility. Does the person have a motive to lie? Is this abuser, do they have a pending criminal case against them? Do they have, or are they on probation or parole? That could be a reason why they have an incentive to lie against, the complaining witness in that case. Or, looking at USCIS's own version of, what is considered credible. If abusers like, she married me for a green card, well, where's the detail? Where's the specificity that USCIS says they want to see? Where's the corroboration? If all the corroboration is that this was a real marriage, or someone had mentioned also if the abuser said under oath previously that this was a good faith marriage and now they're going back on that. Those are some ways to contest credibility. Next slide, please. And a lot of you probably know this already, but just wanted to remind folks that OVW, LAV, STOP, and LC grantees are eligible for ASISTA technical assistance as long as there's a nexus to domestic violence, dating violence, sexual assault, or stalking. You can use the ASISTA portal to schedule an OVWTA appointment. You'd use the OVWTA calendar, and often OVW appointments are available a lot quicker than private member appointments. Next slide, please. And then, Carrie, I don't know if you wanted to say anything more here about ABA.
Yeah, sure. So I think what I most want to highlight is that we have listservs that are nationwide. So if you have a question or you're experiencing something and you want to know if someone else is experiencing something similar, or if you're perhaps working with a survivor that's had run-ins with law enforcement in another state that you may want to try to correct or get more information about, sign up for one of our listservs. It's a great way to connect with other attorneys who may be able to help. Obviously, don't publish any identifying information or details about a case or a survivor on these listservs. There are some that are specifically focused on representing LGBTQ plus survivors, and then there are some that are more generally focused on litigating. If you don't think you meet all of the criteria, still put in your application. Sometimes we make exceptions, we'll put it that way. So please feel free to do that. We also do provide TA as well. If you ask us a very specific immigration question, we'll probably send you back to ASISTA. But if you have questions as to how to be more accessible no, you absolutely do not have to be an ABA member to sign up for these listservs. They are available to everyone. Great question. Thank you. If you do have questions more generally just on working with LGBTQ survivors, how do we find them if we're not seeing them, things of that sort, please feel free to reach out. We do have two whole grants focused on these issues. I see someone raised a hand. I'm not sure if it's for me or for someone else, but I'm going to call on them anyway. I don't know. Can people unmute in our format or are they going to need to put it in the chat?
I think it's in the chat.
Oh, okay. But
No
yes, please sign up
worries.
for these listservs. You do not need to be an ABA member. And with that, I will turn it back over to Kelly.
Thanks, Carrie. Next slide, please. So again, just wanted to say thank you all for joining us today. We really appreciated your participation in the chat. It made the experience a lot more interactive, and we hope that this webinar was helpful to you. Again, I'd like to remind you to please fill out the evaluation that is going to pop up on your screen at the end of this webinar. And then just there's the link here for how to request TA from ASISTA and also how to get on our listservs. Really appreciate you all and hope that you have a great weekend. And thank you to my co-presenters as well.
I see another hand. I'm not sure if somebody has a question that they want to pop into the chat really quickly.
Yeah, this is your time. We have 3 whole minutes.
And sometimes I have a question I can't type quite quickly enough. I was like, no, stop, please.
See folks dropping off quickly, so I will let everybody go. Again, hope you have a great weekend and hope to see you soon in a future webinar or TA.
Thanks, everyone.